married for a second time. So in today's topic, we're going to talk about to get remarried or not to get remarried. That might be the question, but please remember, what I'm about to discuss during the program is for educational purposes only. It is not intended to be legal advice. As always, you need to work with your attorney to determine what is appropriate for you and your estate plan. To get remarried or not to get remarried. Recently, Amanda and I had a meeting with a client of ours who has been a client for a number of years, and he indicated to us that he is considering getting remarried on February 14th, obviously Valentine's Day, a day a lot of folks think about getting married and possibly remarried. And after talking to him for a period of time, I thought it might be helpful in today's episode to talk about some of the things to consider that we had discussed with him before he goes ahead and gets remarried. Now, understand a little indication at the beginning of the program, though, that I'm not against people getting married. I've been very happily married to my wife, Ginny, for many, many years and look forward to many, many more. And I'm not one who's here to talk you out of getting married, but you need to understand the legal consequences of getting remarried and address those legal consequences before you say, I do again. So 3 things to consider before you get married. The first, which is what we normally talk to clients about, is what happens if you die? What happens if you die if you've gotten remarried? Well, what you need to understand is that the state of Michigan creates certain rights that a spouse has to receive an inheritance from his or her spouse. These rights are automatic the minute that you get married. Now, there are 2 types of rights of inheritance, if you will, that we normally look at. One is what are called allowances. And without going into all the details, we tell clients all the time, think of it as though the state of Michigan says, off the top of your estate, we're going to give in the area of $70,000 to your surviving spouse. So you get remarried and die, your surviving spouse is going to be entitled to basically the first $70,000 from your estate. After that, we're now going to look at how large is your estate, and depending, assuming, operating an assumption here, that the person that you are marrying is not the parent of any of your children. And in that case, we're going to look at intestate succession rights. Those are the rights that a spouse has to receive an inheritance beyond that $70,000. And in 2018 numbers, the reason I'm using 2018 numbers is the state of Michigan has not yet published the 2019 numbers. But in 2018 numbers, after that $70,000, which are in allowances, your spouse is going to be entitled to the first $153,000 of your estate, and then half of anything over $153,000. So again, the moment that you got married, state of Michigan says there are these rights to allowances and there are these rights to inheritance. Now, you need to think about that before you get married to see whether or not that is of a concern to you and what planning options you might have, if any, to address those rights. Second, federal law. Federal law gives rights to employee benefits. Those are 401ks. The spouse has to be the beneficiary unless they waive their rights. So we've got 2 things that we have to look at. What does the state of Michigan create by way of rights in a spouse? What does federal law give by way of rights to employee benefits, in particular a 401k plan? Having said that, the rights of inheritance that state of Michigan does give can be waived. They can be waived before or after marriage, and obviously our recommendation would be if you're going to waive those rights or you're going to want your prospective spouse to waive those rights, it should be done before you get remarried. Why? Well, think about that. Once you get remarried, your spouse might not be willing to sign it. Spouse might die before they have the chance to sign it. So it needs to be done before you get remarried. The waiver has to be in writing, it has to be signed, and the most important feature is there has to be a full disclosure of what you own. If you don't make a full disclosure of what you own, that can leave the surviving spouse coming into court saying, hey, I didn't know that my spouse owned A, B, C, or D, and so there was no full disclosure of what it was I was giving up any rights to. So the key to making it work is full disclosure of assets. Now, with respect to federal law on your 401k, the waiver has to be signed before a notary, but it can't be made until after marriage. So there's going to be, even if you do a waiver before you get married, for federal law purposes, there's going to be more paperwork that's going to be signed after you get married. Again, number one, what happens if you die? How are you going to address the certain rights of inheritance that the state of Michigan gives you and that federal law gives you? Second thing for you to consider before you get remarried is what happens if you get divorced. As we all know, not all marriages work out. Even seniors who are getting remarried after perhaps a spouse of a previous spouse has passed away, those marriages don't always work, and we need to plan for that. What about spousal support? That might be if you get remarried and down the road you decide that the marriage isn't going to work, you might become obligated to pay spousal support to your surviving spouse. What about division of assets? The assets that you've acquired during your lifetime, now that you're getting remarried, some of those assets might be subject to division with your spouse if that marriage doesn't work. So what happens if you divorce? And I know many of you are going to sit out there and say, oh, that would never happen to me. That would never happen. I love this person. We love each other. Divorce will never happen. Well, my job as the attorney is to talk to you about what the law provides if in fact that happens, so that you have fully considered the potential consequence of your getting remarried. Now, there is a document. It's called a prenup or a prenuptial agreement that a lot of clients might be familiar with. It's an agreement that you enter into before you would get remarried. And basically, in writing, the parties agree as to what will happen relative to spousal support, what will happen relative to division of assets in the event that the marriage doesn't work. Similar to, if you will, that waiver of spousal rights where you are waiving the rights of inheritance that you have, a prenup is a document that you would sign before you get remarried. What's the problem? The problem is this: in the state of Michigan, even though you have put together a prenup and both parties have agreed to it, when the time comes that there will be a dissolution of the marriage, i.e. a divorce, under Michigan law, the court might determine that it would not be fair to enforce the prenup. Let me say that again. At the time of the divorce, even though you have this prenup that was done, even though both parties agreed to it, the court might determine that it would not be fair to enforce the prenup. And in that case, the prenup will not be binding on the court. So whatever agreement you had entered into by way of dividing assets or with respect to spousal support, you're still in some sense at the mercy of the court in whether or not the court is going to determine that it is fair to enforce it. How do you avoid that? The only way that you avoid that is not to have gotten married. Number 3, something that many clients, particularly it's important to seniors that they don't think about before they get remarried. What happens if your spouse needs to go on Medicaid? Medicaid being what? Basically a program where you're asking the government to pay for your long-term nursing home care. Seniors, obviously there can be a lot of health issues with seniors. It's mostly, certainly seniors that end up in long-term stays in healthcare facilities, and many of those seniors can't afford to pay for it. So what happens? Well, what's going to happen is your spouse is going to make an application to the government to receive Medicaid. In making that application, though, the government is going to look at all of the assets that both you and your spouse own to determine whether or not they are going to be considered eligible. That means the government lumps everything together. They don't care if it's yours. They don't care if it was yours before you got married. They don't care where it came from. They simply look and say, we're going to treat all of the assets that you have and all of the assets that your spouse has in determining whether or not they are going to be eligible for Medicaid. And when they do that, if there is too much by way of assets between you and your spouse, those assets, not just your spouse assets, including your assets, are going to have to be spent down before you get to the point that your spouse is going to qualify for Medicaid. What does that essentially mean? That means that because you are now married, your assets might have to be spent to take care of your spouse, not just your spouse's assets. That can leave less assets in your estate to take care of you. That can mean less assets in your estate to leave for your children to inherit. 3 things, then, for you to think about before you get remarried. 1, what happens if you die? 2, what happens if you divorce? And 3, what happens if your spouse needs to go on Medicaid? Now, sometimes, for some clients, once they do this analysis and look at these 3 factors that we've talked about today, they will oftentimes determine that legally, it is not a good idea for them to get married. Many seniors today, I realize many seniors grew up in a whole different generation when marriage was looked at differently, but you will find many seniors today are determining that they are better off simply residing together than getting married. If you're not married, you can still love someone and not be married. You can still provide for someone and not be married. You can take care of your loved one in your estate plan without being married. If you're not married, there are no rights to an allowance. There are no rights of inheritance. There are no rights to your 401k. You don't have to worry about what's going to happen if the marriage doesn't work because you're not married, and you do not have to use your estate to spend it down before your loved one is going to qualify for Medicaid. So for those reasons, Amanda and I, in meeting with a client recently, looked at the client, was all said and done, said, you need to think about whether or not you would be better off not to get remarried. Now, as I understand it, some churches out there, some religious organizations out there will in fact have what's considered a commitment ceremony. It's similar to getting married, but you're not getting married. I've actually had clients who will go through the process of getting, quote, married, but they never get a marriage license. So they have a service and they have friends come and they have a get-together, but they never have a marriage license by which they are going to legally be married in the state of Michigan. Side note, I had a client a number of years ago. She was in her 80s, talking to her by phone. She was from the Upper Peninsula, and she was thinking about getting remarried. Having many of the conversations that we just talked about during this episode today, other than Medicaid. Medicaid planning was different back then. Unfortunately, Medicaid planning has changed recently, where you don't have options as the surviving spouse that you perhaps, or as the, not surviving spouse, as the spouse that you used to have, which is why many more of your assets are going to be at risk now if your spouse needs to qualify for Medicaid. But in my conversation, talking to her, going through this very conversation that I'm having with you today, at the end of the conversation, she says to me, well, Tom, I have one further question that you haven't addressed, and that is this. If we get married, is it going to be in the newspaper? I thought that was an interesting question. Why are you concerned about it being involved in the newspaper? I've talked about all the legal issues. What's the importance of the newspaper? Well, she related to me after I said to her, well, it probably will because you live in a small town in the UP. She indicated to me that, in fact, they had been living together for about 20 years now, had told everyone that they were already married. They wore wedding rings. They joined the country club as husband and wife. So for all purposes outside their immediate family, everybody thought of them as being married. So there are people out there who make the specific determination that they will love each other, that they will care for each other, that they will provide support for each other in their estate plans, but they don't get married so as not to subject either spouse to the legal issues that we've talked about in today's program. Again, if you're thinking about getting remarried, I'm not against getting remarried, but be smart in what you're doing. Take a look at what you're doing, understand the consequences of what you're doing, and make sure that you have operated and taken all steps to protect yourself.